before.
Hi, Bongi. How do you paste Ilona? I
Recording in progress.
Good morning, honorable members, and good morning to the colleagues from the Special Investigating Unit and our colleagues from the committee staff. I'm hoping that everyone can hear me. So this also serves as a sound check.
Good morning, Honourable Chair. Yes, we can hear you clearly.
Thank you so much.
Good morning.
Advocate Motibi, good morning.
Good morning, Chair and colleagues and honourable members. Thank you for the invitation.
No, thank you very much. I am just going to do a short introduction. So today, in fact, to the members and members of the public, we had a presentation by the Auditor General yesterday on the State Information Technology Agency, as well as the SA Broadcasting Corporation, the SABC. So we are continuing with that theme today, in that we discussing the same institutions, but with a special investigating unit, because there are some open proclamations, or the completed investigations, and some open proclamations in respect of both institutions as well, which the special investigating unit is going to update the committee about, so that when we meet SITA, SABC, and the minister in future, we are equipped with all the information that we need for that purpose. I want to thank you, Advocate Motibi, for providing the committee with a copy of the presentation ahead of time. It's been distributed to members, so thank you very much for that. We appreciate it. It was helpful in our preparations for this morning. I am not going to waste time at all, because we've got one presentation today. Let's just get through the presentation by yourself first. What we will do is we'll just watch the time, Advocate Motibi, at about 10:30, 10:45. We may need to take a break during question time, I'm sure, just to give the members and yourselves an opportunity for a body break. But otherwise, I'm going to hand over to you to take us through the presentation.
Thank you, Honourable Chair and honourable members. As indicated, we really appreciate the opportunity, as always, to appraise the committee of the investigations that SIU is conducting in various state institutions. Today, we focus at the State Information Technology Agency and the South African Broadcasting Corporation. We will go directly to the proclamations in the portfolio. Just the other slides are really the slides that deal with about SIU and so on. Can you please go to the overview of the proclamations? Oh, I see. Yes. Overview. Overview of the there we go. Thank you. Honorable Chair and honorable members, you'll see on number 1, it's the focus on the South African Broadcasting Corporation. It really dates back a while back, 2010, and we did so because we wanted to be comprehensive in the information we really present to the committee. And then the next one is the one of 2017. The investigation has been complete, and we'll give the committee the fair details around that investigation. And then we've got the State Information Technology Agency, which dates back as well to 2014, but it was amended in 2015. the focus of this investigation has been really to focus on some of the procurement irregularities that occurred at SABC and SITA. Well, just to conclude the list, number 4 is the proclamation that was recently published that focuses at what was called the TNA breakfast events that were held, supported by various state institutions, as you can see them there in brackets, SABC being the platform that was used, Eskom, Transnet, SAA, Petro SA, and the Department of Human Settlement. We will be investigating at all of those state institutions. It's still very early stage now, and we will indicate in the presentation that there are no outcomes yet on this one. The next slide, please. Right. These are really just a summary of some of the outcomes reached in the SABC and SITA investigations, Honorable Chair and Honorable Members. On the SABC one, and we will go into some detail, we've saved through our investigations about 151 million, and including the cash recoveries of about 33 million. On the SITA side, we've discovered the savings about 111.3 million and cash recoveries of 24.6 million. There is a contract that was set aside, and as I said, really this is just an overview. The contract is a contract that was concluded between SITA and IBM, as in International Business Machines, to the tune of about 265 million. And I'll just say a bit, Honorable Chair, around that contract in few minutes. And in terms of the referrals, there's been about 10 criminal referrals, 6 at SABC and 4 at SITA. As is usually the case, we're following up with NPA in terms of what became of that. Similar to the disciplinary processes, we would like to really be able to report that they've been attended to, failure to attend, why the failure, and so on. On the civil litigation side, there's about 11 which are detailed in the SABC presentation, and about 2 administrative actions and 1 administrative action on the SITA side. The civil litigation block there is a bit, it's blank because we joined SITA to institute the civil litigation in the High Court. So we were party to it, but in the main it was SITA really instituting the proceedings. And those proceedings led to the contract being set aside. We of course contributed in terms of the findings of our investigation. As we were saying there, the TNA media is still underway. There are no outcomes at this stage. If you can just slide on. Slide on. Right. As I indicated, Honorable Chair, before I hand over to my colleague. By the way, I should have just indicated, Honorable Chair, I'm joined by my colleagues. All of them have been attending consistently at Scopa. I'm going to be handing over to Ms. Zodwa Kasibe, the Chief National Investigating Officer, who will be doing the presentation further. But just suffice to say here that the SITA investigations were mandated, as I indicated, by Proclamation R48 of 2012, and it was amended in 2014, and again amended in 2015. The focus area, as I indicated, Honorable Chair and Honorable Members, is the procurement of IBM with a view to supply works, goods, and services in terms of an integrated supply agreement. Right? This is the part, Honorable Chair, if I were to just comment now, and I've asked the team, for purposes of enabling Scopa to really execute its monitoring function, and also in the context of the MOU that we signed with SCOPA, is really the investigation was done a while back, and it's important for SCOPA to know what transpired. But the current question is, what was this contract? What was IBM supposed to do? What was it supposed to really actually enable SITA to do for SITA to execute its function of supplying IT services to government? So I've asked the team to check that. And as the Honorable Committee would see, that the contract was set aside, right? Now that's one sort of legal outcome, well, an expected outcome. But the question really is, what became of the services that IBM was supposed to supply to SITA, and what is it that it did? The cancellation of the contract, how did it affect the capacity of SITA to supply its services to government? I think for us, that's really the current question that should be asked. Of course, we investigated also the payments that were made in terms of that contract. And then there's another contract that was entered into by SITA, and we'll take the honorable members through that. And that the contract by IFM, I think they were contracted to do some risk assessments there and so on. But of course, we have found that the contract was concluded irregularly. Now, perhaps I'll allow my colleague to just go through. This part of the presentation is not that long compared to the SABC one. And why is it so? As Honorable Chair and Honorable Members, is that at the time of the SITA investigation, which was really a while back, it happened really just before we really revamped our strategy to say we need to dive deep into maladministration and malpractices and look at the governance failures and so on. The SABC one came at the time after we really had implemented the new strategy, and you'll see we dive deep in terms of the maladministration, governance failures, and so on. But the same questions really arise with regard to the SITA environment. It's just that at the time, SIU did not go into detail as we did at the SABC. My colleague, Mr. Siba, are you able to proceed from here? And Mr. Lekgetho, once we're finished with the SITA, are you able to also come in just to appraise the Honorable Committee around what services was IBM supposed to supply? And the critical question would be what became after the contract was cancelled. Honorable members, I also raised with the team that although these are the proclamations related to SITA as a state institution, we do have other investigations where SITA is involved. Now that investigation is an investigation whom the proclamation related to National Treasury, but as part of the services, SITA was involved, and I'm talking here about the Integrated Financial Management System, IFMS, so-called. So I've asked my colleague, the COO, just to look at what is it that we made the finding against SITA in that environment, and how the nature of the failures or irregularities around SITA. Hopefully, we'll be able to really just show to the committee, because the intention is really to give an overall view, so that when the committee meets with the SITA, they really have this view from our side. Mr. Siba, you can proceed from here, please.
Thank you.
Good morning, Chair. I'm the one who's proceeding here. Mr. Sibe will come.
Okay, sorry about that. Mr. Lekgotla.
No, thank you, Advocate. Good morning, Honorable Chair. Good morning, honorable members, and thanks for the opportunity to present. And still on the slides, as Advocate has indicated, that the SITA proclamation was to look at the procurement and appointment of the IBM, and also to look at the payments which were made by SITA to IBM in terms of the integrated supply agreement contract, which was issued out in 2013. And in terms of this particular contract, Chair, the contract was intended to enable an integrated government services and technology platform between government departments and to ensure more efficient service delivery to the citizen and business entity of South Africa. The service concern held the prospect of SITA becoming the prime system integrator for government services and solutions. That was the real purpose of this particular procurement of this particular item by SITA. Then going on, we also looked at irregular and unauthorized and fruitless and wasteful expenditure as a result of a contract which was awarded to the IFM Consulting, which is the IFM. And on this particular one, we investigated two contracts. The first contract was 10 million, whereby the IFM was procured so that they can come and investigate the break-in which happened at SITA. So they were contracted without following any procurement process, whereby they were just called in to come and investigate. And the other one, which was 265 million, was a contract whereby they needed to come and provide vetting services to SITA employee. When we carry on, in terms of the finding, Chair, the IBM was appointed at a cost of 888 million as a single source service provider without prior permission to deviate from competitive procurement processes as required by National Treasury. And whereas SITA board has approved the above-mentioned integrated supply agreement, that is the ISA, for an amount of 888 million, which was VAT inclusive. The terms of the agreement itself stated that the contract price to the amount of 854, which excluded VAT, meaning that SITA board has approved 888 million, but when the contract was drafted, it was indicated that the contract was to the value of 854 and excluding VAT. And now if we were to include 14% VAT to that 854, then it had showed that the total amount of the contract was more by 85.5 million, meaning that this is not the amount that the board has approved. So as a result, those are the irregularities that we have found out of that process. Again, as the procurement of the service of IBM was irregular, all subsequent expenditure incurred relating to the ISA constituted irregular expenditure. And in terms of the actual payments made, the total amount of irregular expenditure incurred in this ISA contract amount to 774 million, meaning that, and when we came back and asked as to why this contract was entered with SITA, and also during our investigation, we found that IBM, as we know, that most of the government infrastructure was built on the IBM infrastructure. So we were told that the IBM bid that was in relation to this SITA was actually an extension of the already ongoing contract, whereby they wanted to add more feature into it. So the procurement for this, we found that it was really not followed accordingly. And when we found that when we asked SITA as to why they're not following the procurement process, they indicated that the service that is being rendered by IBM has been rendered for over many years, and most of the platform of government are on the infrastructure, on the IBM infrastructure, meaning that for them to move away from IBM to look for any other system, it's gonna take them more than 5 years for them to build that system. So as a result, that's why they just kept on renewing and renewing in terms of the IBM system. But from our investigation, the whole contract was cancelled ultimately after the intervention by both parties in relation to our investigation. Then with regard to the IFM was appointed without any competitive bidding process being followed, and IFM submitted a false TC, that is tax clearance certificate, and they had not prescribed security clearance. As we know that SITA it's a key, one of the key state institutions whereby anybody that entered that or worked there needs to obtain security clearance, and IFM did not have a security clearance. Then they were not registered by PCIRA, as we know that the service that they wanted to provide to SITA was a security services. So we found that those services, those irregularities were identified out of the contract which was awarded to IFM. Then in terms of the outcome, we did refer disciplinary referrals, that is 22 matters were referred to SITA for non-disclosure of business interest, and a letter of demand were written by SIU and for the longer standing money to SITA, which was paid, and there was saving to the value of 111 million, whereby the contract was terminated, one of the contract was terminated, and we refer 4 criminal referrals to NPA, and of which one was to the AFU. And we also referred 1 referrals for blacklisting, whereby SITA, we required it that they should blacklist one of the firm that provided services to them. Then in terms of the civil outcome, with the support and assistance of SIU, SITA lodged an application in the High Court, Gauteng, under that case number to have that 265 million, which is the contract which was awarded to the IFM, to be declared invalid and set aside, and of which it was. And the agreement, it was the court ordered that the agreement concluded between the applicant and the respondent is unconstitutional and invalid, and the agreement concluded between the applicant, which was the SITA, and the respondent, which was IFM, was set aside, and the respondent was ordered to pay the cost of the application. So that is all in terms of the SITA investigation that we have investigated. Then from now on, I'll hand over to Mr. Siba to carry on with the SABC investigation. Thank you, Chair.
Mr. Lekgato, before you hand on, with your permission, Honorable Chair, Mr. Lekgato, if you are able to, at this stage, while we are dealing with SITA, to show a picture, as I requested, of the IFMS irregularities. If you're not ready yet, it's fine, but let's prepare them so that we can give the Honorable Committee a picture of that as well.
Maybe, Chair, I can prepare it and present it for now. Yes, yeah.
No problem. Honorable Chair, as I indicated, it will really be good to show a picture of where we have SITA presence in our investigations, and up to now, it's these investigations and the ones at in the IFMS space. There is no other area where SITA was looked at in our investigations. Chair, that is now the SITA investigation. The procurement itself was investigated, irregularities found, consequence management reached. But as I said, the bigger question is, what became and what is the current status? As my colleague indicates there, from a business perspective, it looks like IBM had really entrenched themselves. And I recall at some point, the concept of evergreen crept in terms of how long more is SITA going to be dependent on IBM? But of course, that's really a business question that really can be posed to them, and whether the system is enabling them to supply the services to government. In terms of disciplinary processes and the others, we made disciplinary processes, even including the executive level of the management at SITA, because we were of the view that they didn't apply their minds as requested or as required. So it was really a good outcome from that perspective. Mr. Sibe, you can proceed now.
Thank you, HIU. I'll just show my face and then close it for network purposes. Good morning, Honorable Chair, Honorable Members, Head of the SOU, colleagues. As indicated, we had two major proclamations around SABC and also then the recent one, which emanated from the Zondo Commission of Inquiry. I've just closed the video now for network purposes. The SABC won the 2017 proclamation, R29 of 2017. It emanated from the ad hoc committee that was established by Parliament on the fitness of SABC board. Then the committee released their final report, and then the SIU took that report, analyzed it, and obviously we then also received a proclamation to investigate the same affairs. Next slide, please, Mr. Lefeto. In terms of the main investigation, we looked into 9 specific contracts which are listed in our report. And Chair, with your permission, I'll take the report as being read. I'm not going to go through every aspect of the report. So we only investigated the 9 contracts that were concluded between SABC and the entities that are listed there: Lona Vision, Vision View Production, Sekela Xabiso, SCA Incorporated, Lizav Consulting, the Geconomics, trading as Infonomics, Asante Sana, Foxtalk Communicating, Mott McDonald, and MultiChoice contract regarding the sale of SABC archives. So those were the contracts that we looked, and the values are that we also considered are listed in relevant to the companies. Next slide, sir. So we phased this investigation into phase 1 and phase 2. So the investigation, as already indicated by Advocate Motibi, was concluded, and what is left is then the civil litigation processes. And then I will pause here, Chairperson, and allow Advocate Vanara to take us from slide 15 to slide 26 as an update on the civil litigation process on the matters. Over to you, Advocate Vanara.
Thank you, Mr. Sibe. Good morning to the Honorable Chair and Honorable Members and colleagues. Please don't leave this slide. Yes. This slide really gives an update on the outcomes of some of the matters to date in terms of the savings and recoveries. The first matter really relates to Mr. Mosoneng's bonus fees that was paid subsequent to a board decision. To date, the amount has increased from 11.5 million, which was paid because of the interest that would have accrued, to 18 million rands. Of that amount, there has since been an amount of just over 6 million rands that would have been paid from his pension benefit from the SABC pension fund. We have finalized this matter, and we're going to speak to it in detail later. The Vision View matter relates to a 52 million rand contract that had been set aside. This relates to the construction of the newsroom studio, which is currently being used on Channel 404. That contract was set aside. We are claiming a recovery of just over 6.3 million, which is in relation to profits that Vision View would otherwise have been entitled to claim for constructing the studio, but for setting aside the contract, they were deprived that opportunity. Consequently, we're sitting with a studio, a world-class studio at the SABC offices, for which the SABC only paid the service provider for the expenses incurred by that service provider. Matt McDonald, this matter was resolved between the parties with a settlement agreement which led to the payment of 1,250,000 into the SABC coffers. Mr. Mutsoning's legal fees, some members would recall that he had apparently used the SABC funds to pay for his personal matters, to pay for fees for his personal matters with his personal attorney. We've recovered the amount of 851 rands, together with interest and costs to the tune of 1.2 million. Rapid Blue, which was one of the service providers to the video entertainment production lineup, that matter had been settled with a payment of just below 200,000 rand. The Asante Sana claim of 350,000 rands, there was a savings which the SABC did not pay, consequent to our intervention. Similarly, with the TNA media, there was a claim by the company against the SABC, and this relates to the breakfast shows that were being conducted utilizing equipment, airtime of the SABC without monies being paid. And because there was a claim against the SABC for payment that was allegedly due to TNA, we were able to then save, through opposition of that claim, 145 million rands, because this company has eventually gone on to liquidation, and the liquidators have not pursued their claim against the SABC. The last on this slide is the SABC Legends payments, which were the 50,000 rands paid by to the Legends. There was already a 2.4 million paid. We took that decision to the special tribunal and have it, to the court, High Court, to have it reviewed and set aside. And we have since saved the SABC 5.8 million in respect of monies that were still due to other Legends, which they would have claimed from the SABC. But for our intervention and declaring the decision unlawful, no one can come and claim the 5.8 million from the SABC. Next slide, please. Sekela Klabiso, this was an auditing firm that was doing some audit work at the SABC. Again, it was highlighted in the Parliamentary Committee inquiry on the SABC board fitness to hold office. We had a saving of 600,000 rands through a settlement that resulted in the computation of the loss that the SABC would have lost. The matter, we did not succeed, and we discussed it later on in court, but we, however, did save the SABC an amount of 600,000 rands. The pension payout, this is the 6.4 million I earlier referred to in the previous slide. With respect to Mjaeli Security Pty Limited, this was a contractor that was appointed by the board to provide security services when it was a second bidder, ignoring the recommendation to appoint the first successful bidder. So Mafuku, actually Mjaeli, was the successful bidder that was not appointed. Mafuku Securities, which came second, was appointed, and Mjaeli then, together with the SIU, took this matter on review, and the court has set aside the contract to the tune of 185 million. However, Mafuku is challenging, is appealing this decision. That is why we're unable to quantify the amount of recoveries at this stage. Next slide, please. Thank you. These slides from slide 17 to slide 27. Honorable Chair and honorable members deal with a summary of the status updates on the civil litigation matters in relation to phase 1 of the investigations conducted at the SABC. We deal with the phase 2 cases in slides 34 to 39. Of the slides 17 to 27, we will be discussing 11 cases. There's 4 finalized cases, 1 partly finalized, and 6 pending cases. What the honorable members would have already picked up in preparation for this meeting is that the beneficiaries of the irregularities that unfolded at this institution are not lying down. They're putting a fight to protect their gains, and to a certain extent playing delaying tactics that are delaying the finalization of these matters. With regard to the first matter, the first 3 matters that I'll be discussing, the one is already on screen. And in the interest of time, Chair, please allow me not to read each sentence. I take that the presentations would have been read. The first 3 matters involve, again, Mr. Motsuneng. They involve the board, and therefore, we consolidate the 3 matters. The first one relates to the claim for damages suffered due to irregular staff appointments, unlawful increments, unlawful termination of staff contracts, as well as the success fee payment that relates to the first 3 matters. The current one really relates to irregular staff appointments and increment. That matter, we are placing it on setting it down for a pre-trial conference. If you go then to the next slide, please. This one relates to holding the board accountable. You'll see the first respondent is Professor Magube, who was the then chairperson of a board which had taken a decision and made a payment 0.5 million to Mr. Motsuneng. we're holding the board responsible for the decision. However, we're threading carefully, as I indicate in the next slide, we are discussing a matter that involves Mr. Motsoeneng on the same success fee. So strategically, we have halted on number 2 because we are still pursuing recoveries from Mr. Motsoeneng. If we recover the full amount from Mr. Motsoeneng, we would not then incur expenses and bother to pursue the board. However, at this stage, indications are we are most likely to also pursue the board to recover the remaining amount from what we are recovering from Mr. Motsoeneng. If you can then go to the next slide, please. Sekela Xabiso, this matter has since been settled with a payment of just over 6 million rands back to Sekela Xabiso, which was for the services that they rendered. We did take the matter to court. We lost, and the court then allowed the parties to resolve the issue of who owes who how much. And that's where the 600,000 saving was made to the SABC. The next slide, please. Vision View was a company contracted to build the new studio. The company was irregularly appointed. We brought an application to review the decision to award the tender and the subsequent contract, which we were successful. And the SABC, as I indicated earlier on, saved an amount of just under 6.4 million. And they have a world state-of-the-art studio that they're continuing to utilize to date. Next slide, please. Lorna Vision and James Aguma, the claim really results from payments in relation to a contract that has since been declared void. We have to date obtained a judgment by default against Lorna Vision. We have attempted to execute on this company. Unfortunately, it's where you see a company that received a contract of just over 62 million. When you have a judgment against it, you are unable to recover the money as there are no assets in the company. What we have done, you will see in the subsequent slide, is then to pursue the directors of the company, as we are of the view that the directors use the company to company assets to enrich themselves. If you go back to slide 6, we are also pursuing Mr. Aguma, who was at some point a CFO, as well as the acting group chief executive officer. We have now since obtained a trial date for the hearing of the matter against Mr. Aguma. You remember we did obtain judgment by default against the company Lorna Vision, for which we are pursuing the directors for the actual recovery of the monies. With one of the matters, which was an interlocutory application, which was decided in our favor, we have obtained a warrant of execution after we had prepared our bill of cost and had it taxed to recover the monies. Mr. Aguma's whereabouts at this stage are unknown. However, we have enlisted the services of a tracing agent to assist locate him on a basis that we only pay the tracing agents when they have been successful in locating Mr. Aguma. Next slide, please. With regard to this matter, number 7, we are really essentially pursuing the directors of Lorna Vision to really to pierce the corporate veil and hold the directors liable. There is a lot of dilly-dallying, there is running away. And this matter, we have applied for a hearing date, and we are waiting for us to be afforded a date so that this matter could be heard and disposed of. The next slide, please. Number 8, which relates to Ms. Bessie Tugwana. Ms. Bessie Tugwana's matter really relates to the Vision View matter, for which has since been finalized. We have applied for a trial date, but there are discussions internally to determine a way forward on this matter, given the outcome that we have obtained in the Vision View matter related to the construction of the studio. Next slide, please. The Geckonomics matter, we have finalized this matter. This is one of the matters that is partly been finalized. In that, judgment was handed down on the 1st of September last year, and which set aside the contract and the subsequent, or the decision to award the contract and the subsequent contract itself. We were a bit unhappy with this judgment, albeit it was in our favor, because it deprived us an opportunity to recover monies that we think are due to the SABC. Because once the decision is reviewed for lack of want of regularity and the contract is set aside, the successful bidder is not entitled to the profits, and we do want then to recover the profits this company would have made. We did appeal the judgment, and we are awaiting on the 15th of October for the hearing of our appeal by the full bench of the Pretoria High Court. Next slide, please. On this matter, this really relates to fruitless and wasteful expenditure that was suffered by the SABC as a result of Mr. Rapela's conduct. We did interdict the pension benefit so that we are not sitting with a hollow judgment once the main review application has been finalized. This matter was set down for hearing last year in November, from the 18th to the 29th of November, but the matter could not proceed as the defendants wanted documents from the SIU, and the judge gave the SIU a day to deliver the documents, which are voluminous, and they date back to many years ago, which we were unable to do, and an order was made against the SIU, which we have since appealed, and we were granted leave to appeal, and we are busy with the necessary preparations in respect of prosecuting our appeal. The next slide, please, which is the last matter on phase 1, relates to Matt McDonald, which has since been settled between the parties with a payment of an amount of 1.2 million paid to the SABC on the 28th of February 2023. I'll pause here, Chair, and later on come back later in the presentation. Thank you.
Thank you, Chair. Now I'm going to be providing an update on the referrals made to the NPA by the SIU. Chair, we've already indicated that we referred evidence in support of 29 matters to the NPA. And to date, Chair, we can safely report on one matter where one person has been charged. On the Motsweni matter, the case is currently on trial. And the trial started on the 27th of March 2025, and the case then was postponed to 4 June 2025. In respect of the remaining criminal referrals, they involve private companies who contracted with SABC, its directors and former SABC directors. The combined value of the cases is around 267 million rand. The charges vary from theft, fraud, contravention of Companies Act, and PFMA. These NPA referrals were done between 2018 and 2020. So we then requested NPA to allocate a dedicated prosecutor to deal with all these SABC matters. And then we are still waiting, Chairperson. In respect of the investigation relating to the success fee paid to Mr. Motsweni, we made the following criminal referrals. There was evidence pointing towards the criminal offense committed in respect of payments of this success fee against 3 former SABC officials and 2 former board members. And these one were referred to NPA on the 9th of June 2020. Next slide, please. Then an update on the disciplinary referrals, Chairperson. We have referred 24 disciplinary referrals to the SABC. The evidence in relation to these matters implicates 14 officials, all of whom have been charged. And these officials, they involved 7 SABC executives, 8 SABC officials. 13 of the 14 matters have been finalized to date. The latest referral was on the 6th of May against the board member in respect of then the SABC security contract. The impact of these disciplinary referrals have been exciting because then it involved at least SABC executives and officials. So 5 executives are no longer with SABC because 5 were found guilty on disciplinary charges and 2 were dismissed and 3 resigned. 4 resigned in the face of SIU disciplinary referral. 1 executive contract expired and was not renewed. 2 SABC officials were dismissed because they were both found guilty on charges of misconduct. Next slide, please. Then there's an update on administrative action taken. We referred 2 SITA referrals against Mr. Aguma as well as Audrey Rapella. And on the basis of their irregular approval of and payment of success fees in respect of certain cases that are listed here in Chair, as well as then Mr. Rapella in the sense that also the contravention of her professional conduct in the approval of these success fees. Next slide, please. Then now we move to then the second phase of SABC investigation, Chairperson. This phase involved the following matters: the TNA business breakfast, SABC security tender, irregular appointments of 7 SABC officials, alleged irregular payments of bonuses, irregular expenditure of 5 million rand on SARS penalty, and conflicts of interest. This is just then the slide. I'm still going to continue with the others. In terms of then these matters, the report that the SIU can provide is that around the TNA breakfast, business breakfast, the evidence obtained indicated that TNA involvement in the SABC affairs were intertwined with their involvement with other state entities, such as Eskom, Transnet, Petro SA, and other entities like human settlements, which then indicated that the SIU should then motivate for a further proclamation, which proclamation was then received last year, and it's part of the report at a later stage. In terms of the security tender, Chair, this investigation has been completed and the civil litigation is underway. In terms of the 7 officials that were appointed irregularly, we found no evidence of irregular appointments in the appointment of these officials. In terms of the bonuses, the 13th check, no evidence to support the allegations was found. And then the SARS penalty investigation is complete, and then the civil litigation is underway. Conflicts of interest investigation is complete, and the disciplinary referrals were handed over to SABC. Next slide, please. Next slide, sir. Okay, the next pack of irregularities in terms of phase 2 was the legends payment of 2.4 million rand paid to 53 artists. The investigation here is complete, Chair, and civil litigation process is underway. SABC Heritage, the thank you concert, 27 million rand that was spent there. The investigation is also complete and no action is to be taken in terms of this investigation. Rapid Blue, the factor season 1, no civil action. Settlement discussions concluded between SABC, SIU, Rapid Blue, and the repayment made to the SABC in terms of this contract. Irregularities regarding the lease of the SABC offices in Nelspruit. Case has been finalized against the SABC and the SIU. Then irregular payment of Mr. Mutsuneng's legal fees. The SIU successfully obtained judgment ordering Mr. Mutsuneng to repay his legal fees to the SABC. Next slide. Then there were also various allegations at the Northwest SABC office. And then these ones included the appointment of the provincial general manager. Then in terms of this one, we briefed council on the 19th of December with a view to have his appointment set aside and also to recover any undue payments made to him. The position is that he has since been dismissed. As far as the recovery of any monies are concerned, the SIU decided not to pursue the same as insufficient assets for potential recovery could be traced. Then the next one is the appointment of the provincial news editor under the same Northwest SABC office. Investigation there is completed and no irregularities were found. Then the specific allegations regarding the official doing business with SABC. Also, the investigation, the SIU investigation is complete and no irregularities. Corruption and abuse of SABC resources. We prepared criminal referrals in line with this aspect. Next slide, Chair. I think I will pause here now and then allow Advocate Vanara to take us through then the update on the civil litigation along these matters. Thank you, Chair.
No, thanks, Ms. Klasib, once again. Thanks to the Honorable Chair and Honorable members. This is phase 2 cases. There's 7 of them, and 6 have been finalized, including one that is partly finalized. We say partly because there is a judgment, but there is an appeal that has since been noted and is being prosecuted in the Supreme Court of Appeal. On the SABC security contract, Mjaeli, earlier on referred to this matter. This is the successful, not successful, this was the bidder that scored the highest points in a procurement process, but was not appointed. Rather, a second scoring bidder in Mafuku was appointed. This bidder, as I indicated, took the SABC to court. Subsequent to the phase 2 investigations, which pointed out irregularities in the process, the SIU joined as a party to review the decision to award the tender and set the subsequent contract aside. Judgment was delivered in October 2023 in favor of both Mjaeli, which had abandoned the proceedings, and the SIU had to carry the proceedings forward. Was reviewed and set aside, and the contract was declared void since its inception. We then started with a process of exchanging audited statements to determine profits and in that process, Mafuku took the matter to the Supreme Court of Appeal for an appeal which is pending before the SCA, and we are awaiting a hearing date of the matter. This decision, Honorable Chair and members, you would recall, after the board of Professor Makuve was disbanded by Parliament, an interim board was appointed, chaired by Ms. Kweyama and others. I think it included Mr. Matata Tsedu. So they were the board members that made the decision to award the tender to Mafuku instead of Mjaeli. And there were adverse findings that were made against them. And they then brought an application to review and set aside the SIU report because they didn't like what the evidential material had pointed and the subsequent findings that had been made. The two matters were joined, and needless to say, their application to review and set aside the SIU report was dismissed, but there was no order as to cost. The next slide, please. The TNA media, I think there is now a new proclamation to look at other entities that would have fallen victim of this company, which has since been liquidated. As I indicated, we saved the SABC in excess of 144 million, which was claimed before this company went into liquidation. We are, however, pursuing the directors to pierce the corporate veil, and we are to apply for a new date for the hearing against the directors. Next slide, please. The legends payment, we took the matter to the High Court to review and set aside the decision to pay Legends the 50,000 that some had already been paid that amounted to 2.4 million. The contract was the decision was reviewed and set aside. We saved the SABC 5.8 million. What was outstanding was a decision around the 2.4 million that related to payments already made. After further reflections between ourselves and the SABC, we've come to the conclusion that it is not worth the while pursuing the 2.4 million rands, given the financial positions of the affected individuals from whom we would have had to recover the monies. So that then brings the end to this legends payments. The beauty about it is that there is people that would have came forward to the SABC and said, you paid people similarly placed in our category 50,000 each, you didn't pay us, we want to be paid similarly. And that would have amounted to 5.8 million. Because of the judgment, they are unable to do so. And that is the value that this litigation brought for the SABC. Next slide, please. I'll hand over at this stage, Honorable Chair, Honorable committee members. Oh, sorry, there's one last matter. And that matter relates to the Nelspruit accommodation. So the SABC has got offices in various provinces. They needed accommodation for their provincial offices in Bombela, and they irregularly entered into this lease agreement, which we pursued. Regrettably, the court found against us in this matter, and were then unable to secure favorable outcomes. Next slide, please. This relates to a matter that Mr. Motsoeneng was challenging the Public Protector's report on ethics and governance fail at the SABC because he was of the opinion that this was the basis of many of his problems, and he believed if this report was set aside, it would alleviate some of the many cases that were lodged against him. Unfortunately, he was not successful, as we successfully opposed, and he lost that matter with costs. The next slide, please. This is the matter I referred to earlier on, where Mr. Motsoeneng got the SABC to pay his personal legal team on a personal matter, which we recovered the 1.2 million, which included a capital amount with interest and legal costs. That is it from my side, Chair. I'll hand over back to Ms. Klasibe. Thank you.
Thank you, Chair. This is an update on the disciplinary matters that we referred to SABC. We referred one against Warren Lesabe, an executive producer, and the SABC elected not to proceed with the disciplinary action against her. Then the second one was against the program analyst, Chantal Mowing, and then she received a written warning. And the senior secretary, Caroline Sindani, she was found not guilty. Then against the one, the assistant commissioning editor, Gladys Mabelane, she also was given a written warning. The driver, Victor Dladla, she was also given a written warning. And the interim board member, Ms. T.S. Lamini, she resigned prior to the disciplinary hearing. These were referrals, Chair, on the conflict of interest matters that were identified by the SIU. Next slide, please. Chair, this slide now and the following ones relate to the update on the governance review that was conducted on the SABC. The SIU requested the services of a governance expert to conduct a review on the governance structures that were in place at the SABC and the failure, therefore, of these governance structures and how these contributed to the position that the SABC found itself in during the period. The findings were communicated to the SABC board at a presentation that was done in 2020 February. The review period that was covered for the purposes of this review, Chair, was from 1st November 2011 to 31st March 2019. And the scope of the review covered at least 146 policies that we identified as pertinent to the SIU investigation at the time. The detailed scope and the mandate are set out in the governance report. The SIU then submitted the report to the SABC former chairperson and thereafter to the board. So at this stage, the SIU is cognizant of the feedback from the SABC that during this time, the SABC has also simultaneously performed work on the governance of the SABC. Then the strides made by the former SABC board in improving governance in that space were also reported to the Office of the President, with our report. Next slide. In the main, Chairperson, we found the following issues as breakdown in the ethical governance, and the key areas that were identified was on oversight and monitoring by the key structures, the audit committee, the board secretary, the company secretary, as well as the board committees. We also identified a culture of fear and the culture of doing nothing and the culture of poor consequence management. We also identified that then the key people who were appointed in the key positions like board, there were skill set were not fit for the purpose. That is the board and also the strategic positions within then the SABC, the executive management. We also identified as part of then the governance review the behavioral patterns, Chairperson, where we reported on political influence, willful disregards for internal controls and policies, and there was also an element of abuse of power by those who were in charge. And we also identified that their policies, Chair, and their controls were outdated and incomplete and not embedded in terms of then the structures and also not implemented in some instances. Next slide, please. This now, Chair, talks to then the effectiveness of the policies and controls, the statistics. About 65%, Chair, of their policies and controls were outdated policies, and then 13% were policies that were requested and not received. Then the 9% refers to ineffective internal controls or governance protocols. And then we also identified 9% of policies that were high-risk functions. And we also identified policies that were overlapping with other policies and controls. Next slide, please. Then we also identified then policies that were paralyzed, Chairperson. There were policies that were outdated and that needed a review. And there were also those that were overlapping with the existing policies. Then the issues around management override over internal controls, Chair, then we also identified that. and then these ones, they rendered all the controls and policies ineffective. And then we also identified that most policies were not aligned to King 4. Next slide, please. So in terms of then the willful disregard, Chair, this is just then the patterns that we've highlighted in our report. In terms of then the hierarchy, you'll notice that there were all those issues that were identified where we feel that the behavior or it actually equal to willful disregard of any policies in the environment. Next slide, please. Then in terms of the effect of then this governance breakdown, we looked at then what was the impact of all of these, and in terms of then the expenditure reports and the irregular expenditure that was reported. And with the years that are there, Chairperson, 2014, 2015, the irregular expenditure was sitting at 2.6 billion, but it rose in 2015 and 16 to 5.1. Then 2016, 2017 was 4.4 billion. And then 2017-18 it was 4.9. Then it rose again in 2018 to 2019 to 5.2. Those were the years relevant to our investigation and then the governance review process, Chairperson. Next slide, please. Then fruitless and wasteful expenditure in millions, Chairperson. We're looking at 2014-15, we're looking at 61 million rand, 61.8 million. Then 2015-2016, it was 92. It also increased. And then 2016-2017, it was 145.9 million. And then 2017-2019, it rose to 230 million rand. And then 2018-2019, it was 454 million rand. Next slide, please. And then we were trying to also understand the root causes for these issues. And then the ones that came top, Chairperson, was the issue of unsuitable executive that were appointed. They were unsuitable for the positions that were appointed in. And then also there was issues around tone at the top. There was a culture of laissez-faire, Chair, and then the culture of impunity, and then also the issues of inefficient oversight and monitoring of controls and the governance processes. So in essence, the control framework was paralyzed by abuse, and then which therefore equated to the treatment that requires an adequate response. So next slide. Then in response by the SABC, there was a response, and then in the main, it was mainly to focus on the culture of the SABC. I'm not going to go through the entire report there, Chair, but mainly there was specific action recommended against specific individuals, which the SIU has made referral against, where actually we felt that, SABC needed to take action on misconduct cases, or as well as then the criminal conduct in respect of those. So it was more on the culture. It was setting then the tone at the top. The next slide. Then we also recommended regulatory amendment to some of the matters. So these are just recommendations from the SIU. The PFMA, we were of the view that we need to criminalize gross negligence as a deterrent. In terms of the conflict of interest, we also were of the view that a blanket prohibition on employees to provide goods or services to SABC was an issue. We also was of the view that, there was a need to legislate similar to Section 34 of Higher Education Act, some kind of a prohibition by employees to conduct business with the institution. Also was the liability, the stewardship of the trustee. Our view, Chairperson, was that the SABC should then provide for personal liability of employees and recovery through deduction from benefits. And then consequence management was also another issue where we felt strongly that maybe a deregularization of disciplinary hearings in line with labor court decisions and PAJA. And then the prevention from the public press, prevention of the public press from funding personal battles. And this stems strongly from the Mutsoneng case, where we recommended that at least maybe there should be an approval to regularize the recoveries of legal costs where gross negligence has been the cause of action in terms of then the issues where members are misusing the public purse for their own actions. Next slide, please. Then we also recommended the external monitoring and oversight. So we were of the view that to ensure the actual implementation and its efficacy, monitoring should not only reside in internal SABC structures, given the lessons that were learned in our investigation, but also external oversight bodies. The board to report to certain issues to the president's DPE task team. So these bodies and monitoring mechanism could include sending the SIU report to the Auditor General for them to consider in their audit plan, extending reporting lines for internal audit to Department of Public Enterprises, the then Department of Public Enterprises, or dedicated structures, allocating forensic practitioners to internal audit capacity, and including focus probity audits on high-risk areas as identified in our governance report. Those were some of the key recommendations as well, Chairperson. Next slide, please. Then we had some observations, Chair, in terms of our investigation as always. Then we observed that the existing policies and procedures at SABC, as already indicated in our governance report, were bypassed by the board and senior managers, which led to the financial issues of the corporation. There were general abuse of power by the SABC board and senior managers. There were also controls that were repeatedly bypassed through management override, collusion, and abuse of power. So then their internal controls, they became so much ineffective. There were limitations due to segregation of duties in the issues relating to internal control measures that were put in place, Chairperson. Next slide. We also recommended that the SABC should return to the culture that encourages honest discussions surrounding ethics and ethical challenges, with one another and their managers to allow the ethical behavior. The employees should be empowered by explaining what constitutes unethical behavior internally, and then which would be then the deterrent to the issues that happened in the past. We also recommended that they should also know what their rights are and be encouraged to report such before it becomes a widespread problem. Whistleblowers also must be provided with protection, which will encourage employees to report problems, and that would foster an organization that is ethical from top to bottom. We also recommended that the employees should be held accountable and responsible for their behaviors and decisions. Changes should come from management team by identifying the negative behaviors and substitute them with positive changes. Next slide, please. We also recommended that management should follow correct procedures in appointment and promotion of employees. And then it also should be realized by those charged with governance when implementing the recommendation contained in this report that the efficacy of governance structure is not determined by the existence of the structure itself, but how it operates and responds to ethical and governance dilemmas. Then we also recommended then the risk should be updated to prevent risk from governance and audit perspective. And then we also recommended the maintenance of an ethical culture as an inherent obligation of all employees. Zero tolerance action to abuse or non-compliance with internal controls. We also recommended that it should be prioritized to avoid some of the issues. Slide number 55. Chairperson, this is now our target awareness campaign where we have now engaged the SABC. We've started engaging SABC for the SIU to start with this process of the targeted awareness campaigns. We are in touch with the CEO, the current CEO. However, the response is very slow, Chairperson. We reported in 2020 already that as part of its revised operating model and a new value chain, the SIU has identified a need to render the prevention and advisory services to affected state institutions, and SABC was identified as such. So our initiative in this targeted awareness campaign is aimed at assisting the affected institutions to prevent the recurrence. It's more of a preventative measure, Chair. And the campaign is a value add and does not form part of the proclaimed investigation. This is something that we want to then provide to the institution as an add-on to our services, because we bear the cost of organizing the campaigns as the SIU. Chairperson, that concludes then the report on the SABC. We are going to move to then the recently proclaimed matter, the TNA media. Chair, there is not much that we can report in terms of this investigation, in the sense that this was proclaimed as part of then the state capture recommendations, and this investigation involves about 6 entities, one of them being the ESCOM, Petro SA, SAA, Transnet, National Department of Human Settlements, as well as then the SABC itself. These are the entities that were coerced to hold those breakfast meetings and breakfast meetings by the TNA, at the time called the New Age, and they were then paid SABC because the SABC had a contract with TNA at the time. So our involvement in the SABC in regard to this will be just to follow those payments that were made by the state institutions through SABC to TNA. I will pause here, Chair, and then that will end then the presentation for today. Thank you.
Thank you. Thank you, Honorable Chair. I noticed that it's a minute before the time indicated by Chair to break. That's our presentation. We can take questions, but it's really interesting to note, particularly on the SABC part, that our indication of the impact, the governance breakdown impact, ended at 2018-2019. With the benefit of the Auditor General's report, 2021, 2022 to 23-24, it looks like there was an improvement with 99 million, 35 million, 35 million irregular expenditure, and then there was a steep from 2021. That's really an indication that something went wrong. And 23-24, we are back to the billions of 2.8 billion. That really aligns with our view that we need a focused approach to come up with a focused prevention plan that will really assist the corporation going forward. I need to underscore that I have spoken to the current GCEO, and we are really seeking to ensure that the process gains momentum speedily. We have received quite a good cooperation from her, and we are pleased with that. But we really want to see the overall prevention plan implemented that would really assist the corporation. Thank you, Honorable Chair.
Advocate Mutibi and your colleagues, Mr. Lekgetho, Ms. Tlesibe, and others, thank you very much for this presentation. You are correct. I think we kind of got to exactly the time that we said we would take a quick break. Since we are doing okay in terms of time, because the next meeting is at 1 o'clock for me, at least, is all the chairs of committees, but I think we should be done by then. May I propose that we give everyone if we can come back at 11, so it's 10:30 now. If we can come back at 10:45, so that we can just stretch our legs, take a break, make coffee, and so on, and then we'll resume with questions from then on. And then at the end of the questions, we will adjourn. So we'll be back at 10:45.
Okay, thank you, Honorable Chair.
Thank you.
Recording stopped.
Welcome back, honorable members and Advocate Motibi.
Recording in progress.
The recording stopped as I was getting ready to to speak. Okay, thank you very much. Honorable members, now is the time to pose questions and make comments to Advocate Motibi. So I am just going to record the hands in sequence. So Honorable Isaac, your hand is up first. Do I have another hand? Honorable Neil May, you will be the second. Honorable Madlala, you will be the third. So we've got 3 hands for now. Honorable Isaac, Honorable Neil May, and Honorable Madlala. So I will then give an opportunity to you, Honorable Isaac, to go first. And then straight after Honorable Neil May, as soon as Honorable Isaac is done, you can step in. And then it will be Honorable Madlala, and then I see Honorable Skosana G will be on. So let's take those 4 for now, and then we'll give the SIU a chance to answer. Thank you very much. Over to you, Honorable Isaac.
Good morning, Chair. I thank you again for the opportunity. Advocate Motibi and team SIU, good morning to you colleagues. Chairperson, I'm really going to try to be very brief and to the point. I firstly would just like to commend Advocate Motibi and team SIU. I want to extend my gratitude and thanks on behalf of all of us, and I'm sure I speak as well for the committee that it's a job well done to the team, and we're very grateful for the commitment. Chair, if I can get into the presentation, it is indeed a very intense presentation, as we all were able to witness from the slides. But yesterday, Chair, we received, as you are well aware, we received the report on the SITAs, and of course from the AGSA, that is, as well as the report from the AGSA on the SABC. And this now culminates into the report from the SIU regarding these 2 entities. I'm not going to get into detail regarding the reports of yesterday, because obviously it was a damning report to have to listen to as to what is transpiring at SITA as well as at the SABC. I think I might have mentioned, there just seems to be no accountability within these institutions, and there's absolutely non-compliance across the board. And of course, we're seeing billions being just squandered. But nevertheless, to get into the SIU report, it is very sad that these institutions have collapsed to this level, and we've witnessed the corruption of the 9 wasted years. But nevertheless, Chair, let me be concise. I just want to understand, I don't want to get into each detail or slide. I just want to understand 2 or 3 questions. On slide 30, there was alluded to regarding the 2 SITA officials. I just want to know, that is the South African Institute of Chartered Accountants, there are 2 officials there. Are they still practicing, or have they been reported? I just wanted to understand that one. And then, in a nutshell, based on all these matters that are now, of course, in the public domain, Chair, what I'd like to understand, and maybe somebody from the SIU could shed some light on it, is, has SARS been involved in pursuing all these individuals that have been implicated? Are there any lifestyle audits being conducted? because surely these individuals are living a pretty quality lifestyle. And again, Chair, just a comment. I mean, surely all these individuals that are implicated here must have assets. Sure, these assets are obviously lodged in various trust or PTY limited companies, or or transferred to other family individuals, etc. So what I need to understand is, ISA's being involved here, lifestyles audits being conducted, and what is the position regarding their personal assets. Chair, I'll stop there, and I thank you again for the opportunity.
Thank you very much, Honorable Isaac, for those questions. I will then move on to Honorable Neil May.
Good morning, Chairperson. Good morning, Advocate and your team. And thank you very much for the presentation. Advocate, my questions, you made a statement talking about IBM and the consequences of the cancelled contract. And immediately my mind went to that obviously they had server, storage systems, mainframe, specialized broadcast hardware. Did you, in your investigations, check was the equipment leased or was it purchased outright? And is IBM still providing support for some of the services that they have that is critical? And that leaves the question of the risks of operating without the system. I was only halfway yesterday. I was only managed to be in the meeting for halfway as I had to go to appropriations. But I did pick up the challenges that they are having with regards to ICT. And I was wondering if government had based their whole ITC system on the IBM frame. And I think it's in defense, it's in all over because they were the early providers. What did you find that there were any backup system for that SABC had taken with regards to the loss of the IBM contract? And it was just really interested in checking that did something else replace it? That was one of the questions. I think the other area is showing on governance and the oversight by the board, looking at what is the role of the board versus the role of the SABC. And one then looks at how interference in those structures. So one of my questions was also, do you think some of these companies knew that they were appointed irregularly? Because obviously they might have or should have or had a corrupt relationship with staff members. And yes, I also saw those that had not given their members interest. So I was just checking in that sense of the governance part. Did these people really know, or are they playing ignorance with regards to the contracts? The other questions my colleague had mentioned before. Thank you so much.
Thank you, Honorable Neil May. Over to you, Honorable Matlar.
Thank you, Chair. Thank you, and greetings to the SIU team and colleagues of SCOPA. The first question relates to SITA with regards to the tender of 888 million that was awarded without any competitive process, leading to an irregular expenditure of 774 million. And I think there's also another one for IFEM or something like that, which is a security company that had no clearance and not registered with SIRA. I want to check if there was any consequence management for the board, or maybe let me just say the consequence management chain for the approval authorities. So from whoever was involved in the entire process up till the board level, was there any consequence management for that decision having been taken? And also there is the 22 disciplinary hearings referred to SITA. Maybe I may have missed a slide on that. If we can be taken through back to that in terms of the breakdown. When were these referrals made? How many have been finalized? And what has been the outcomes of those that were finalized, and how many are still pending? Coming to the SABC, a similar question relates to the issue of Mchaeli, who was then appointed irregularly. And then I know that there's been an appeal process by Mafuku. And I believe that Mafuku was ranked second, but appointed. And then Mchaeli Mafuku was ranked second, but appointed. And then Mchaeli was not appointed, but subsequently there was one in court and there's an appeal. I need to know also, similar with the IBM tender, if there's been any consequence management, because I'm trying to drive a point which I have insisted on in the past some meetings, that there seems to be lack of consequence management for irregular decisions, even if there was no financial benefit. But board members must understand that in the process of exercising their fiduciary responsibilities, if they take decisions without due consideration, and those decisions result into litigation that is lost by courts, because you've got legal systems within companies, you've got all forms of consultation that can be done, and legal opinions that can be sought before decisions are made at board level. So there should be consequences where decisions are made that are irregular, so that board members don't get away with it by just resigning. So that's on the Mchaeli issue. I would like to also check what were the issues there, what were the recoveries, and what were the consequence management, to just sum it up. And then there was on one matter, unfortunately, I couldn't register it properly. But there was an issue in SABC where the SIU briefs us that they have paused pursuit of board members for recoveries, giving due to the pursuit they are employing against Motswaneng. In which case, if the recoveries are made from Zwaneng, then the other one would fall off. I just want to get some clarity on that, on the logic of that, because beside the recoveries, there's an issue that the recoveries are attached to a behavior that needs to be corrected. So if the board was involved, if the decision was made by the board and the then CEO, or the then board and the then CEO, I would be of the view that suit, and then they should share the responsibility of the recoveries, and not one. If we recover from one, then the other ones, what happens to them? Do they go off? Just because. So I just need clarity around that particular matter, and I'm hoping that it will be remembered by the SIU team. And then the SABC officials who resigned at the face of SIU investigations, I want to also check if there were any other further steps taken on those officials, despite having left the SABC at the time. Then there is an issue of a DC amongst the hearings that were referred to the SABC. There's one DC against the executive producer there on allegations of conflict of interest, which the SABC opted not to pursue. I would want to establish if there were any reasons provided by the SABC not to pursue that disciplinary hearing, as advised by the SIU. If not, what has since then happened? So it was just dropped off, and those who are in, because from the look of the schedule, it seems like it would have been subordinates that were subjected to a disciplinary process. So what happened to the executive producer till today, if there's anything at all? And lastly, as a comment, I think I like I agree with the view, or with the assessment by the SIU of a laissez-faire kind of a culture and impunity at SABC at an executive level. It sums up exactly what we see from the report and what we got from these outcomes. So, as a comment, it's not just it just confirms what we have also been saying, not just at the SIU at the SABC level, because all of these things happen at board and at executive level, and they happen over years, which makes it impossible that at an government executive level, this information would have not reached. Then there was no completely a vacuum or a gap in terms of connecting what is happening at the SABC and what is the responsibility of the executive in government, and also what is government oversight responsibility. So the culture of laissez-faire is a government culture, is a leadership culture in the country. It cuts across all the institutions of the unwillingness and a deliberate lack of consequence management to facilitate a tunnel of flow of corruption and money laundering and money theft in these institutions. So it really says what we've been saying is a problem. And I think I'm not going to reiterate in terms of what I suggested yesterday to be what needs to be done. But we appreciate the honesty of the SIU in dealing with the problems as they see them, because the culture of impunity, if you've got this kind of culture and atmosphere in any organization, it does not matter how much regulations and how many policies you put in place. There is just not going to be an end in the scourge of corruption and in the scourge of underperformance and irregular behavior in these institutions. We're just going to keep flowing and swimming against the ocean. And unless we deal with and nip it in the bud, we are not going to have an end and a turnaround of the situation of governance in this country. Let me just pause there for now. Thank you, Chair.
Thank you very much, Honorable Madlala, for those questions and comments. Shall I give a chance to Honorable Skosana?
Yeah, no, thank you very much, Chair, and good day to all honorable members and the SIU team led by Advocate Muti and all other stakeholders present. Yeah, no, we really appreciate the report from the SIU and the good work that the SIU is doing in pursuing these different cases. Just few questions from my side. On the IBM contract of 888 million plus, which was 888 million plus VAT inclusive, which was approved by SITA board. However, it was awarded at 854 million rands without VAT. So my interest is in knowing in finding out from the SIU in terms of your interaction with the SITA board, because the SITA board approved this contract at 888 million plus VAT inclusive. Now, but at a time when the tender was advertised at 854 million without VAT, I think obviously they should have picked that thing. They should have realized that there is something wrong here because the amount that they approved was 888 million plus VAT inclusive. But even if you were to exclude VAT, if it was advertised without VAT, it was then going to be even less than 800 million rands. I think it was going to be somewhere around 764 million rands. So when they see 854, I think they should have realized that there is something wrong, because the amount it should be 888 if VAT is inclusive, but if it's without VAT, it should be even below 800 it should even below 800 million. So if it is advertised at 854, they should have at that time realized that there is something wrong with this particular advert. So I just want to find out what is their reaction to that, because I think that these things should have been stopped at that level during the period of advert, even before the service provider was appointed, and then SITA had to incur all these irregular expenditure. So I want to understand what is their reaction. What was their reaction to that? To say, yes, they have approved this thing at 888 million rand plus VAT inclusive, but when it went to tender on a different amount, though the different amount was without VAT, but when they do their own maths, they should have realized that even if this amount is less, but is without VAT, but when we are going to add the 14% VAT, it's going to be above the 888 million rands. Then at that particular point, they should have acted. They should have realized that there is a problem here. Acted. So I'm interested in knowing what was their reaction regarding that. Coming to the issue of Jaeli. If I've heard correct, I think Jaeli went to court. Jaeli was supposed to be appointed, but Mafuko is the one that was appointed. It means Jaeli was the rightful company that was supposed to get the tender in terms of the supply chain management processes. But it was not appointed. Mafuko was appointed. Then Jaeli took the matter to court. But at some point, they abandoned the case, if I've heard correct. And then it is the SIU that came at a later stage to revive the case. So I'm interested in knowing why did Jaeli decide to abandon the case when they had such a strong case. I mean, it just does not augur well with me that a company that has had a strong case like this, then they go to court, but then in the middle of the process, they just decide to abandon. So is the SIU aware of why did Jaeli decided to just abandon the case in the middle of the process? Then my next question is with regard to the SABC Legends payment of 2.4 million rands that which was paid to Legend. We appreciate that SIU managed to save the other 5.8 million rands that was supposed to be paid to other legends by halting the process. But I just want to understand why were those legends paid? Those were paid at 5.4 million. Why exactly were they paid? For which work were they paid? Yeah, we know that we are people that support the fair treatment of workers in this particular country. That when people have rendered service, they should be compensated in a fair manner and all that. But we don't believe that we could just pay people without any work being done. So I just want to understand if they say there was a project of payment of Legend. It was the payment for what? Is it for some work that they did some other time, or they are just being paid just for being legends? I just want to understand that. Then on the issue of Mr. Saudi Mutsweni, I understand that there's an amount of 18 million rands plus in process of execution that relates to his bonuses. that relates to the 11.5 million rand bonus and other related cost. But I see that there's an amount of 1.2 million rand of legal fees and interest that has already been recovered. So I want to find out whether was it recovered from Mr. Mutsweni, or it was recovered from who? Then my last question. My last question is with regard to, I don't know whether it's Mr. or Miss Besi Tukwana, I think, who's implicated in the awarding of Vision View contract, which led to the incurement of a fruitless and wasteful expenditure of 42 million rand plus by the SABC. So what was the Mr. or Miss Besi Tukwana's position in this particular regard? Because I see that I think we are only singling him or her in this particular instance. So what was his or her position and his or her role in relation to this particular contract? And then are there any other role players that were involved in this particular case apart from him or her? Thank you very much, Chairperson.
Thank you, Honorable Skosana, and thank you to all the memorable, it's not memorable, honorable, but you are also memorable as well, honorable members. Can I please hand over to Advocate Motibi and team to deal with the questions, beginning with the first questions from Honorable Isaac. Thank you.
No, thank you, Honorable Chair. My colleagues would come in on some of the questions, but just starting with the Honorable Isaac, we appreciate the kind words from all the members, and indeed, the investigations were really quite intense in both instances, and as you can see on the SABC part, that we even went further. And as I said, that really coincided at the time when we implemented really the new strategy of saying, as SIU mandated to investigate maladministration and malpractice, of course, and corruption, but we needed to up the game on the part of the maladministration and malpractice, which invariably points to the level of governance failures. And we did that intensively. That is really a blueprint that we produced at SABC. And really in agreement with Honorable Madlala, this is what is really prevalent in other state institutions. And we have taken this approach that we did at SABC. We will do a deep dive in terms of governance, investigation, and maladministration at all the state institutions we're investigating, particularly the SOEs. We're busy at SAA. We'll do the same at Dinel, PRASA. In fact, with PRASA, we've really started because there's a new proclamation there emanating from the Zondo Commission. We'll do the same with the TNA, just to really understand why is it that there was this kind of behavior. So over and above the irregularities that we're seeing in disregard of policies, procurement processes, and so on. And when we really look at it from a systemic perspective, Honorable Chair and honorable members, is that each and every business process of the state own, well, any other business anyway. In particular, here where we're investigating SABC and SITA, each and every business process will probably have an owner, of course, ultimately culminating into the board. But what we've found, an example of those areas in SABC, you know, the studios and the payment of legends and all of that, those were the processes that decision making was made, you know, by certain officials and executives. But from a consequence management point of view, we didn't just end at official level. I'm really glad that we a while back said when we institute consequence management, we need to look at all levels, what Honorable Madlala calls a chain of accountability. We do that from a junior official up until the board. Typical example in SABC, where the SABC board or directors were also held to account. They even took us to court, and the court ruled in our favor. We were really pleased to see that being demonstrated. So the extent of the investigations really goes to an extent of pointing out all of those, you know, governance failures, process failures, failure by people, and all of that. The involvement of SARS, Honorable Isaac, and my colleague, Mr. Lekgetho, can probably come in. We involve SARS invariably where we find that there has been infractions relating to legislation administered by SARS. Of course, when it comes to lifestyle audits, as SIU, we do conduct those lifestyle audits. We do have a methodology that we use, but indeed, where appropriate, we of course, you know, enlist the services of SARS from the point of view of, you know, lifestyle audit. But in the space of the SITA, I cannot recall that we involved SARS because there was no evidence that pointed to the need to involve SARS. Yes, the issue around lifestyle audits, and then the assets of individuals, where we find that there are irregularities and that the officials and the board members or any other one contributed to the damages suffered by the state institution, we do cite them as part of the litigation process. So from a SITA perspective, I'm going to just allow my colleague, Mr. Lekgetho, if you can just stand by. From the 22 referrals that we made, at what levels they are, and so on. And if you don't have the details, please say so, and then we can provide the honorable committee with those. So in brief, we didn't involve SARS at this stage at SITA because there was no indication at the time to involve them. IBM contract, Honorable Neil May. Yes, that was really our concern amongst others, and this is obviously a systemic issue that really needs to be probed more. As my colleague indicated, that this was almost like a contract to add on to some of the services that IBM was providing to SITA to provide the overall service to government. But there was a clear dependency. As we speak today, we haven't determined whether SITA is really still so dependent as it was at the time of the investigation on IBM. Because I recall at some stage when we engaged them, they indicated that if if they didn't go with IBM, the infrastructure is likely to collapse, and that services to government would suffer. But that in itself, especially at the age that we live in now, that there would be multiple service providers, I think SITA need to take into account the provisions of Section 217 of the Constitution when they really procure going forward. But from an infrastructure perspective, whether it has been built only along the lines of sort of IBM capability, I think at this stage we cannot opine on that. SITA would really have to indicate, and whether they've really reconfigured the government ICT infrastructure such that other service providers can also offer their services. Did they have a backup at that time? And that's why I raised the question that when the contract was signed, was cancelled, Mr. Lekgetho reminded me that the contract was actually cancelled, as he says, by agreement, but that's when we indicated all these irregularities. But at the time of the cancellation, the question now becomes, what happened? And this is whether there was a backup, whether the services that were supposed to be provided by IBM, were they provided by any other service provider? Those are the questions that SITA will have to provide. The role of the board at SABC, as I indicated, that when we investigated, we did probe the role of the board in various decision-making processes, and we made findings against them, and they ended up, of course, being unhappy, and they took our reports to court, and the court ruled in the favor of SIU. Do we think that the companies knew that they were appointed irregularly, particularly at SABC? There is, as we speak, and my colleague can come in, Mr. Siba, there is no indication at this stage that there's no evidence that points to the knowledge by the companies that they were appointed regularly. Otherwise, we would probably have gone further and visited them with the charges under PRECA, which is the Promotion and Combating of Corrupt Activities Act. But at this stage, it's really more around irregularities. And again, because there were irregularities, that's why we went even up to ensure that even the board members answer to those irregularities. Mr. Honorable Madlala, it's again around the SITA contract, the issue around consequence management. The contract was cancelled based on some of the irregularities that we found, albeit by agreement. But the issue then raised is the 22 disciplinary referrals. Who is involved in those referrals? The 22 at what level? I've indicated to my colleague, Mr. Lekgetho, to come in to indicate at what levels. If we don't have them now, we will make sure that in 7 days' time we provide those details. But we are really pleased that we were able to reach those outcomes, and we'll provide even the details around when were the disciplinary hearings made, are there any still pending, and so on. The point that I know is that the referrals were made up until the accounting officer, well, in the ICT or in the SITA space, the accounting authority would be the board. So the chief executive, I think, was also pointed at that time. The issue around the Mjaeli and Mafuko, I'm going to allow Advocate Vanara to come in to really indicate. I think Honorable Skosana also asked around Jaeli on whether they abandoned the litigation or not. All I know is we made the finding that Mafuko was appointed irregularly, and we took the matter to court, and the contract was declared, was set aside. So that's as far as we went, and my recollection says Mjaeli did join the proceedings. SABC officials who resigned in the face of investigation. Yes, as we always say, that if you resign, although you terminate employer-employee relation, you'll still be pursued civilly, you'll still be pursued criminally. As part of some of the examples, you'll see in the Lorna Vision matter, as an example, James Akuma, who was once the CFO and the acting group CEO, he was also pursued from a civil litigation perspective. But Ms. Krasiwe, if you can just add on in terms of other examples, if any. But as a principle, we do ensure that where the resigned official contributed to the damages suffered by the state institution, we pursue them. And where there's criminal or evidence pointing to criminal action by those officials, we pursue them. The SABC not pursuing disciplinary hearing. Mr. Sibe, if you can come in on this, whether we are aware of any reasons given and what happened to the executive producer. Yes, I'd like to also really just, at the risk of repeating and apologies for that if I sound like I'm repeating, the governance failure, investigation really has pointed out quite a number of similarities across state institutions. And Honorable Chair and Honorable Members, these are the systemic issues that we would like to focus at going forward. With the observation of the various state institutions, we could then approach, at least at this stage, the state institutions either on a secondment basis, or where there's a need, we could then process the proclamations so that we look at systemic weaknesses and failures, similar to what we did at SAA. Well, in areas where we've got proclamations already and investigating, we will do that. But on a wider scale, Honorable Chair and Honorable Members, we are really of the view that the systemic approach that the committee identified is really the approach we should take, amongst others. And that will then foster, the culture really of state institutions being proactive and really identifying the weaknesses and dealing with them. And this would include, various institutions such as Auditor General and the others who are relevant. And Honorable Skosana, on the IBM contract, why was the contract not stopped at the time when there were inconsistencies with the amounts? That really it's a question, and that is why, amongst others, we made that finding that it's irregular. But Mr. Lekgeto, if you've got additional information, you're able to provide. Why did Mjaeli abandon the litigation? On Advocate Vanara, if you can be on standby. And then the legend payments. The legend payments, yes, I mean, this was a decision taken by SABC. It really still a question that, you know, all this were found, you know, to be irregular payments, and that's why they were stopped. And in Mr. Mutwening's case, you know, this is really, amongst others, the level of consequence management that we reach, and correctly so, the board members who were involved in the decision around his bonus or any other matter, they should also really be held to account, and we will ensure that that happens. But as we speak, we have gone, Mr. Mutweni has challenged our findings from the lower courts, which is the High Court, to the Supreme Court of Appeal, to the Constitutional Court, where all the way the ruling was in favor of SIU. As we speak now, and Advocate Vanara can confirm, he has now taken the Constitutional Court judgment. He's going back to the Constitutional Court so that they can, review or rescind their own judgment. You know, really, yeah, this is when I think we will be qualified to say there's an abuse of court process, and we will be asking for the appropriate costs here. But in the meantime, as the team, we have identified all the assets that would be able to meet the requirements of paying back what Mr. Mutwening has benefited. I'm going to allow Mr. Lekgetho, if you can come in, please, on the SITA side, and then Mr. Sibe on the SAB side, around the officials, you know, resigning in the face of our investigation, and then Advocate Vanara, you can come in. Mr. Lekgetho, please.
No, thanks, Advocate. Thanks, Honorable Chair and Honorable Member. On the issue of SITA regarding the SARS, yes, we did engage SARS. I think SARS is the one that managed to confirm that the tax clearance that was submitted by IFM was false. So there was working together in terms of us and SARS. Then in terms of the list of the DC Chair, can we submit the details regarding the position, and we can also try and get the status as to what happened to those DC. It happened quite a long time ago. So can we submit a written response with regard to that? And on the issue of the IBM contract regarding the 888 and the other, including VAT and the other. So what happened is that the board approved the 888 contract to be awarded. Then when the contract was made, in the contract, they wrote 854 excluding VAT, meaning that it happened after the approval of the board, where the board has indicated that we approve 888. Then for them to put 854 excluding VAT, it means then the addition to that 854, it's 85.5 million, meaning that the total amount is gonna go beyond 888 million. So that's what happened. It happened at the issue of the contract. Remember, this tender was not advertised. It was just awarded to SITA, and it was awarded to SITA because, to IBM, because IBM currently, by that time, was already in the SITA space. And also, with regard to this contract, as we have indicated that the procurement was not properly followed, but as a result, we in terms of the consequence, we did try to analyze and sit down with SITA to understand that based on the fact that it was not really, it didn't follow the process. However, in terms of the service that you have rendered, was it really justifiable and was it really needed? we have found that SITA's entire IT infrastructure platform has been developed and also been redeveloped and deployed and maintained by IBM since before 1990. So meaning that IBM has been at SITA for a quite long time. And SITA has heavily invested in the IBM system, whereby everything that they were doing was in the mainframe of IBM. Then meaning that it necessitates that IBM can only offer some of the services that SITA wanted. So I think that's how the monopoly was developed over a number of years. Then we engaged SITA to say, I mean, you really need to observe the 217, that is the procurement process. Then I think that's where they came in to say, if they go on to do the procurement services, then they're going to have to, it's going to take more than 5 years, because all the systems that our government is running have been built on the IBM. Those systems include like PESAL, the criminal record systems, and all this system. So for them to cancel, it's really going to interrupt government, whereby government will really not function. So those are the engagement that we had with them regarding this system at that particular time. But we did highlight the issue of the monopoly, that there are possible systems available in the market where they need to justify themselves that there's no anybody that can provide whatever IBM is doing before they can start awarding this contract to IBM. That's why we end up making this matter to be an irregular expenditure. And in terms of it, the then CEO was at the forefront in terms of this. Then we did try to make a disciplinary referral against the CEO. By that time, the CEO has left the SITA employment, so that's why we couldn't make referrals for the CEO at that time. I think those are the questions that I needed to answer in terms of this matter. Thank you, Chair.
Well, thank you, Mr. Lekgetho. Honorable Chair and honorable members, I did indicate earlier on that I asked Mr. Lekgetho to check the SITA involvement in the IFMS space for purposes of being comprehensive with areas where we are investigating and that there's SITA involvement. On the IFMS side, and Mr. Lekgetho, perhaps you can also come in, there wasn't any specific findings of irregularity on the part of SITA in the IFMS space, which we could point out and indicate to the Honorable Committee at the moment. However, they were supporting National Treasury. The whole procurement was at National Treasury. So for purposes of today's presentation, we then couldn't find areas in the IFMS to present. Ms. Kasibe, are you able to come in and really throw some light on some of the questions at SABC?
Yes, thank you, HOU. Thank you, Chair. On the SICA question by Honorable Isaac, we against our referrals on Mr. Aguma and Rapela, we have not received any feedback from SICA. However, Chairperson, we can then request again feedback from SICA and then provide feedback to your office as soon as we get that, together with the reasons by SABC on their failure to discipline one of the officials in one of the referrals under the conflict of interest, that is RN. So we will then be submitting those ones. And then on the question by Honorable Madlala on SABC officials who resigned at the face of EDC, Chair, we can safely report that we referred our disciplinaries and the disciplinary process was already been embarked upon by SABC, and then the officials resigned. So it would be the SABC then that will then be that will have a responsibility when such reference letters are requested from them to report that there was a pending DC against those officials. From our side, we have referred the DCs. And I think I will pause here, Chair, in terms of our matters, and then I'm not sure whether HOU Advocate Vanara can cover then the aspects of then the civil litigation matters. Thank you.
Advocate Skosana, I'm sorry, Honorable Skosana asked about Bessie Dukwana, that we've singled him or her out. Are there any other role players? Do you have the information? Sorry about that, Honorable Chair.
Oh, thanks. I will provide then the details on that one with the report that will cover the SITA feedback as well as then the SABC feedback and that one. But I'm sure Advocate Vanara may have other details around this one.
Thank you. Advocate Vanara, address other matters as well, please.
No, thanks, HOU. Thanks, Honorable Chair, honorable members. Honorable Neil May asked a question that we think the companies knew of them being irregularly appointed. I know the HOU covered this, but I just want to look at it from a technical point of view. In law, the approach of the courts is that if you are a service provider and you are actively participating in doing business with the state, you ought to know that procurement in the state is regulated, and there's certain procedures that needs to be followed before you get to be awarded a contract. And therefore, the court's attitude is that there is knowledge of the processes that needs to be followed by service providers who participate in public procurement. And therefore, that alleviates us as litigants from the burden of proving the element of knowledge of irregularity. So then what we are expected to prove is the actual irregularities and not the knowledge of the service provider of that particular irregularity. Honorable Madlala asked with reference to slides 17 to 19, the logic of recovering from one and not the other. The logic is premised on the following. One, you can only recover that which you have lost and no more. So that is the first point of departure. Even if there's 10 people, if you can recover from one, you don't need to get additional funds from the rest, because the payment by one absolves the remainder. In this particular instance, we took both the beneficiary of the decision to pay the success fee, who was Mr. Mutsone, in following the money, because the money left the SABC into his account. So that is the first person we've identified. The second person would have been the decision maker. We've taken both of them to task. the report would indicate that at some point we wanted to consolidate the two cases. Unfortunately, whilst we did obtain the order to consolidate, the case of against Mr. Motsoneng had already been at an advanced stage and it had been finalized. And all that we were looking at is how much are we able to recover from Mr. Motsoneng. If we recover the full amount, it makes no financial sense, no business sense to pursue the remainder because we would have received the full amount. However, I did indicate that from where we are, indications are such that we may need to proceed against the decision makers because we do not think there's going to be sufficient monies to recover the full debt owed from one individual. However, had we waited until now, the claim against the decision makers would have prescribed. And that is why it was important to pursue both. So we're not sitting with the risk of a prescribed claim because we've already in court with the decision maker. All we did was to pause to mitigate financial risk in terms of unnecessarily financial spending. There was a question from Honorable Skosana about Jaeli abandoning its case. And perhaps I need to, for the avoidance of any confusion, explain in this context what is meant by abandoning of the case. Abandoning the case means a litigant whose dominus litis in this instance would have been the applicant. The primary applicant would have been Jaeli. They initially instituted the proceedings because they were unhappy of the decision. And we joined them after our investigators found evidence pointing to the irregularity. And the obligation was then on Jaeli to do all that was necessary to prosecute its case to finality. Abandoning means they stopped prosecuting the case. They did not do anything in furtherance of pursuing their case, to an extent that a judge issued directives for the SIU to become the main dominus litis, who then had the responsibility to take the matter to its logical conclusion. And that is borne by the facts of this litigation. As to why Jaeli abandoned, we have no knowledge as to why they abandoned, and we do not play into the realm of speculation. The SABC legends, why they were paid. In summary, there was no services rendered. This was an act of goodwill in recognition of what those who would have been in the eyes of the decision makers then at the SABC would have perceived as legends who would have contributed to the entertainment in the country. With regard to the last question around the position Ms. Bessie Tugwana had occupied, she was at the time in the position of COO, and she's the one that made the decision, and her signature is the one that committed the organization to these transactions, and that is the basis on which we pursued her. Thank you, Chair.
Thank you, Advocate Vanara, for the comprehensive response, including covering the legends payment asked by Honorable Skosana. Honorable Chair, just really a last observation on my part is, as the Honorable Committee can see, really that overall investigations are done intensively, results are reached, outcomes are reached. the consequence management part, and this is really the picture in various other investigations we do, that you would see effective implementation of civil recoveries, but in instances where there are referrals to other parties, that's where really, in our view, really, as a system, we need to really improve. And what are we doing to do that, Honorable Chair? As we indicated before, and we are hoping that in this time of the Parliament, our SIU amendments to the legislation can really go through. Amongst others, we're seeking to have in the legislation that the referrals really be, call it binding, to an extent that, you know, if there are failures, then we need to deal with them, you know, legislatively, because at the moment we're really dealing with them administratively. And now this is where the mechanism that the presidency is working on, which they from time to time would come to SCOPA and update on where they are with the mechanism. We have had an engagement with the presidency recently. That mechanism is really gaining good traction to the extent that officials, accounting officers are really being questioned on why they fail to implement on SIU referrals. And there's a general picture of really the implementation of consequence management. It would really assist if the presidency could update at some point, of course, given the schedule of the committee. But from where we sit, we believe that the accounting officers and accounting authorities really have to sort of lift the bar in terms of consequence management, because that's where we're going to see deterrence. That is where we are going to see that there is a downward trend in terms of maladministration, corruption, and malpractices. Because the extent of failure to implement consequence management then breeds this impunity. Honorable Chair, I wanted to really just make that comment. Thank you.
Thank you very much, Advocate Matibi and team. Can I give other members an opportunity to ask? I think this will be the last round of questions. I'm just trying to see if I'm missing any hands. Okay, there are two. Okay. Honorable Kubeka and Honorable Atkinson, I will give a chance to both of you. Thank you so much. Honorable Kubeka, you go first.
Thank you, Chair, and greetings to the SIU team, and greetings to honorable members of SCOPA. Chair, I think for me, I've got two questions only. I think the first question would be, I'm not sure if the SIU would be the correct people to answer this, but perhaps during or somewhere during their investigations, they would have seen or figured out how this happened. I would like to know, Chair, how was Hlaudi Motsoeneng appointed? And when I ask how was he appointed, I'm looking to check, was there possibly a list of requirements that were put up by the SABC to say these are the requirements we're looking for? Because something doesn't add up here. I'm not too sure how they ended up with that appointment. Now, it's worrying, Chair, that with that appointment, I heard one of the colleagues here from the SIU saying that they had an issue with the board as well, in that the board itself was somewhat questionable in their competencies as a board. So I'm not sure if anyone could speak to that. And then the issue with that IBM contract, I believe, Chair, it's not correct that we could have a contract that is running and still is running from the year 1990. That's a bit irregular. That's not even a bit irregular. That's uncalled for. I get and I understand that bulk of the systems that are there in the country, like the criminal justice system and everything else, resides with or on IBM servers, and IBM equipment is used there. But is there no way that we could possibly change or migrate to a different system? And I say this because if we've got sensitive information that resides with IBM for a period of, say, around, is it not more than 30 years now? With those systems sitting at IBM, are those people not responsible for our sovereignty to a certain degree? Because even if it were to take 5 years to migrate from IBM to a different system, I would believe that that should be considered. I think bulk of the other questions were asked, Chair. I'll hold it there. Thank you.
Thank you very much, Honorable Kupeka. Honorable Atkinson.
Thank you very much, Chair, and thank you very much to the SIU for that very interesting presentation. And I really salute you for the work that you've done, particularly at the SABC, because I think the era of Mr. Tlhaodi Motsoeneng was an era in which he acted with great impunity. It was almost as if he believed he owned the organization, that he could actually make the kind of decisions that he did. And I think what you have done by holding him to account, and also to the board, which enabled a lot of his actions, has really underlined the fact that these institutions actually belong to the people of South Africa, not to any one particular individual group of individuals, but as a state entities, ultimately they vest in the citizens of South Africa, and people are already there in those positions to basically carry out a fiduciary responsibility to manage them to the best of their abilities, which obviously Mr. Motsoeneng really didn't actually necessarily do that. So I'm very pleased to see that action has been taken, and that, as you said, that you're going to be using this as a blueprint for the other state institutions, such as South African Airways and Denel and various other institutions where there have been similar practices that have been carried out that are basically illegal. The one question that I have, one rather disturbing thing, there was the matters that have been referred to the SIU, not to the SIU, to the NPA. I think you mentioned there's 267 million rands worth of basically of money that's been disputed. But they've only, I think, brought fraud actions for an amount of 18,000 rand against one employee. It just seems rather bizarre that so little has been done, and there's so much to be done. We have had the NPA before us before, and I know that Ms. Batoyi tells us that she has an issue with having enough staff. But, you know, in a sense, you kind of laying the gold standard for accountability here, and as you have done with the SABC, and that really needs to be followed through from the NPA as well. So I really hope that you continue to put pressure on her in whatever way you can, and certainly our committee needs to get proper prosecutions done on these things so that we get proper accountability as well. So it was just one little question that flowed out. That was more really a comment on the work that you've done, and the fact that I'm sure that we're all very grateful for what you're doing, because you know, the one great scourge in this country is one of corruption, and you're helping to slay that dragon in whatever way you can. How would Mr. Motsoeneng be funding these various different appeals to the higher courts? Because I presume now that no state funding would be available to him. Would this all be in his private capacity? And would he not face the danger of all the costs actually ending up in his lap as potential frivolous litigation? Thanks very much.
Thank you very much. Honorable Gupek, I'm assuming that that's an old hand and not a new one.
Yes, no, apologies.
Okay,
Chair.
all
I'll
right.
remove it now.
Thank you so much. Advocate Matibi, over to you.
Thank you, Honorable Chair and Honorable members. Honorable Kubega, indeed, during our various investigations, we do also look at the manner in which the irregularities are committed. And as you be aware that we've said it before, that we also do really analyze the methods, which is usually called modus operandi, of how is it that these people commit the irregularities, the maladministration, malpractice, and corruption, and so on. So with particular reference to Mutwening, I did a quick check, and my colleague, Mr. Siba, reminds me that the public protector actually looked at Mr. Mutwening's appointment. We didn't particularly look at his appointment. And Mr. Siba, do you want to come in?
Thank you, HOU. Yes, HOU. Mr. Mutweneng was already working for the SABC. He's been with the SABC for a long time, for a long period, and then his actual appointment to the position of the GCEO was investigated by the public protector, and they issued a report around him and his qualifications and his you know, the manner in which he was appointed without meeting the prerequisite requirements of the position. Thank you, Chair.
Thank you, Mr. Sibe. So I think in brief is that the concern raised by Honorable Kubega really still stands. That appointing individuals in positions which they are not sort of qualified or fit for, not meeting the qualifications and so on. So the question really becomes going forward, as I said, systemically, how is it that, as government and state institutions, that we address the issues of procurement, the issues of recruitment into executives, the recruitment into boards. And these were some of the questions which were raised by the Zondo Commission as well. So from the point of view of implementing the State Capture Commission recommendation, amongst others, is to deal with issues relating to board appointments to state-owned entities, and also to deal with the appointments, of executives. This is really a stark example of instances where there would have been, call it management override of processes and policies where an individual would be appointed to such executive role without meeting the requirements. Honorable Chair, we can check what became of the public protector recommendations, if any, and then possibly report back. But that part was looked at appropriately by the public protector. It is our view that SITA should really consider, Section 217 of the Constitution that says when you procure, you need to ensure that you meet the procurement requirements, and so on. Particularly with regard to, the contract that has been so in place for so long by IBM. You know, are we so dependent as SITA and the country on IBM? Honorable Chair and honorable members, I say this with a qualification that I'm not sure what the status now. Hopefully SITA can appraise on what is the status at the moment, because we believe that there is an opportunity that this space could be opened up to comply with the procurement processes. Yes, could we not migrate to another system? We believe that there's a possibility that SITA should consider that. Honorable Atkinson, we really share your views. In particular, really, we are of the view that now I think Mr. Mutsuening is really abusing the legal process, and this really goes to show. It goes to show that I mean, to a large extent, he really believes that either he shouldn't have been investigated, or really I can't just put my hand on, of course, with the observation that anyone has got the right to a legal recourse, right? It's his right to challenge the findings that are adverse to him. But in the context of our litigation process, I am of the view that really is abusing a legal process, particularly, and I mean, Advocate Vanara can probably opine, but I mean, once the Constitutional Court has made a ruling, yeah, as I say, it's probably his right to go back to the Constitutional Court and say, no, I think you must review your decision. Yeah, it really baffles me. But there are legal processes to deal with that. In the end, we'll ask the court to really issue appropriate costs in this regard. Honorable Chair, I'll pause here and see if there are any further questions.
Thank you very much, Advocate Motibi. I don't know if the members have any follow-up questions. I just have one or two on my side, or maybe it's a comment, specifically relating to the State Information Technology Agency, which is really critical to the functioning of government. That I think it's important that we, following the session that we are going to have with the executive authorities, as well as the accounting officers at SITA, we really need to think carefully about whether the proclamations that we have in place are sufficient, or whether they need amendment, or we need new proclamations, because we certainly got a picture of serious dysfunction and governance failures. I understand the historical issues at the SABC, but from the Auditor General and your reporting, it appears that things are on a better path, although there is a long way to go, and that the committee needs to keep its eyes clearly focused on the SABC as well. Where things are particularly worrisome is when service delivery is affected, and serious information and security breaches can occur across the government estate. And I fear that they may have occurred in many places. We were at PRASA, the issue was raised. You go to other SOCs, the issue of information and IT security is raised repeatedly without any indication that it will get better. So we do need to just develop a clear understanding of what really is going on there so that we may see how we intervene. I also want to thank you for the part of the presentation that related to the SABC, the review of the systemic issues at the SABC, where there was a combination of things. There was political interference, failure in governance controls, poor culture, management overriding, policies outdated, and that sort of thing. And I think that kind of insight, Advocate Motibi and team, is particularly useful to the committee because I think we can superimpose that in a lot of places, including municipalities. And you would find that the picture is exactly the same. So I do want us to see how we can work together with you and the Office of the Auditor General, maybe to arrive at some kind of assessment template that we can have in instances where the audit outcomes are really poor, because I think 2, 3, or all of those patterns that you saw at the SABC are likely to be present elsewhere, because the Auditor General has spoken about culture to the committee and to Parliament in general, and we see the impact of the culture. There are instances where, especially at municipal level, the political interference is egregious, and it leads to other failures. I think if we are to make helpful recommendations to the National Assembly and also hold the presidency and other executive authorities to account in a manner that is has got clear strategic outcomes that are positive for South Africans and service delivery, we have to work together to make sure that we can implement some of these recommendations across different institutions without needing to reinvent the wheel too much in each case. So I want to thank you and your team for that insight. It's incredibly useful. We will also follow up on other things, such as the work that you are doing as a value add in order to sensitize and educate people about how to avoid the mess that we are in. I honestly cannot understand why institutions would not want to go to those things, because I certainly would anytime want to make sure that I am part of it. So there are things that Advocate Motibi we will follow up as the committee, just to understand why certain things that should happen and that are going to help all of us are not happening, so that we can all get on the same page and start achieving the same objectives. So those are my comments. But the Secretariat will be in touch with you so that when we have both the SABC and SITA coming to Parliament, we can coordinate our work. Maybe a further summary, a brief, even if it's a couple of pages, it's not a presentation for the members, to be able to engage with the issues, with the patterns in particular. With the ministers and so on, but we will let you know what the dates are so that you've got adequate notice, Advocate Motibi. Yes, please go ahead.
I couldn't see how I raised my hand on this one.
No, it's okay.
Sorry to cut across. On that one, Chair, we do have a very comprehensive report. This was really just a summary. We can send that report to the Secretariat.
Please,
on the full governance review that we did at SABC.
Thank you.
And
I think that would be helpful.
I do agree that that's a blueprint we can really do across.
Yeah. I mean, there might be some differences in some areas, but when I looked at it, I could see that this could help us cut to the chase. Help us cut to the chase and ask the right questions from the get-go. So thank you very much. The Advocate Motibi, I just want to give you a chance to make any closing remarks before I adjourn, if you've got any.
No, thank you, Chair. Really not much. Really wanted to just indicate that as part of implementing the MOU that we have, the systemic approach that we would like to really assist government generally, including municipalities. And we'll work together to really develop that template based on the blueprint that we did at SABC. Thank you.
Advocate Mutibi, thank you very much. To the SIU team, thank you so much for all the work that you do, not just in supporting the committee, but in supporting various institutions, and very importantly, getting the money back into the state so that it can be used in the right way. I also want to thank the honorable members for their participation today. I think we will be together again, Advocate Mutibi, on Friday, if I remember correctly.
Yes, we have
with,
RAF, Road Accident
with
Fund.
with a report on the road accident fund. So thank you very much, honorable members, and to Advocate Mutibi. We'll see one another on Friday. Thank you.
Thank you.
Thank you, Chair.
all.
Thank you. Bye-bye.
Thank you, Chair.
Thank you.
The chairperson.
Thank you.